Again, we put on the report therapeutic range, but there is higher therapeutic ranges that, depending on your physician, what it's being prescribed for and where he wants you to be. But on our report, we actually have a therapeutic range, typically on the lower end, which goes anywhere from 0.01 to 0.05 milligrams per liter.
Which found was 0.063.
Correct.
Which would be a little higher than the range you have included in your report.
Yes.
And so, so you testified about all of the testing that was done on the blood.
Yes.
Now, with respect to the urine, what was done with that specimen, and what was the analysis result?
We did similar type testing that we would do on the blood. We did various methodologies to do the qualitative to determine what was actually in the specimens. And then we do a confirmation type procedure in the urine to basically identify the drugs that we're finding on the screen.
And what drugs, if any, did you identify in the urine?
We found hydrocodone in the urine. We found cannabinoids. And we also found cocaine metabolite, as well as alpha-hydroxy alprazolam, which is the main urinary metabolite for alprazolam.
With respect to the cannabinoids, what would be the source of that type of product?
Marijuana.
With respect to the opiates, what would be the source of that?
Well, we specifically actually found the type of opiate that was there, which was hydrocodone in this specimen.
Any therapeutic ranges which apply to those other than the cannabinoids?
No, we generally, especially for opiates, we don't generally provide necessarily a therapeutic range because there's such a broad range, and especially in this case, we were finding it in the urine only, so we wouldn't be putting ranges.
With respect to those samples that we're talking about that you have just identified, was any further testing done on those? With respect to those samples right there?
As far as for this litigation package, no.
Yes. Thank you. No further questions.
Cross-examination by the state.
So that I'm clear about this. Blood testing you did disclosed two different substances. The benzodiazepines and the cannabinoids.
Correct.
THC.
Yes.
So marijuana and Xanax, I think, is said was the most common.
Yes.
Now, you indicated that on your report you put down the therapeutic range at 0.01 to up to a 0.05, but they actually can go higher for therapeutic range?
There is another therapeutic range. I believe it goes up to 0.075.
0.075? And that would be above what the level was that was discovered in Mr. Bradley's blood?
Yeah, and again, under a physician's advice, they would be prescribing that.
Now, when you check the urine test confirmed the Xanax and the marijuana, I understand.
Yes.
And then you found some additional drugs in the urine that were not in the blood.
Correct.
How do you account for that?
In the urine, it provides us a longer window of detection. So something you may have taken, say like on a Friday night, after you take that drug, 30 to 60 minutes later, it's going to be absorbed, especially if it's oral, and it's going to be present in your blood sample. But depending on the drug and its half-life, 2 to 4 days later out from that, it will no longer be present in your blood, but you'll still be excreting it into your urine. So it's very common, and that's why one of the reasons we use urine, because it gives us a larger window of detection.
But it also expands the period of time in which the person could have taken the drugs.
Correct.
So, for example, with respect to the additional drugs that were detected in the urine, which I believe you put down as a cocaine metabolite,
Yes.
can you tell when it was that Mr. Bradley ingested the cocaine that shows up in his urine but does not show up in his blood?
No, I cannot.
Any time window whatsoever?
Generally, we say with cocaine, It can be anywhere from 2 to 4 days out, but there are instances, if somebody is a chronic user, that it might be detected further out than the 4 days.
And with respect to the opiates, did I hear you say that that was another form of cannabinoid?
For the opiates, no, sir.
And what was the opiate that was discovered?
We found hydrocodone in the urine.
Hydrocodone.
Hydrocodone,
Okay. Hydrocodone.
yes.
All right. And that did not show up in the blood test.
No, it did not.
And can you tell us anything about when it was that that hydrocodone was ingested by Mr. Bradley with respect to when the blood was drawn and tested?
No.
Would have been, do you have any idea what the half-life is of that particular drug?
Hydrocodone half-life is typically about 8 hours. Of course, the half-lives for individuals do vary, but we generally say it's about 8 hours. But again, we don't know what the peak level was, and if you don't have that information, it's hard to especially look at that, something like that, just in a urine.
So you can't narrow it down for us to say that any of those drugs have been taken within 24 hours of the test or within 24 hours of the test?
I don't have an opinion on that yet.
What is a half-life?
The half-life of a drug is the amount of time a substance takes to be metabolized out of your system, particularly out of the blood. So if I say to you that the half-life for a drug is, say, 2 hours, and if we know what the peak level of a drug is, and I'll just say, let's use an example, let's say it was 10 milligrams per liter or something like that, and if the half-life is 2 hours, every 2 hours that drug level is going to halve. So if its peak was 10 milligrams and the half-life is 2 hours, 2 hours later it's going to be 5. 2 hours after that it's going to be 2.5.
So what you can say is that a substance which is detected in the blood, or perhaps there's a discrepancy between what's not in the blood and urine, would be because substances in the blood are filtered out more quickly and pass through the system more quickly than in the urine.
They are out of the bloodstream faster than they are out of the urine.
Now, is that your area of expertise, how quickly the body metabolizes particular blood and the urine?
I mean, I could certainly testify of particular drugs and half-lives and so forth.
No further questions.
Okay, recross by the state.
Do the drugs in the urine have any effect on the individual?
Your Honor, I would be on this.
Yes, you may. Bench conference.
No further questions, Judge.
Okay, ma'am, thank you for your testimony. You're free to step down.
Thank you.
And this where is the
Okay. Did she need to go through that and take out the corresponding stuff? Okay, those exhibits can go with the clerk. And ma'am, we're going to have you go through that exhibit and take out any correspondence. So if you could do that outside. And I'll go ahead and release the it's going to be Defense Exhibit number 2. I'm going to give that to you for the time being if you'll do that. And then if you'll wait and give that to one of the defense attorneys, and then we can review it. Okay, thank you, ma'am. Okay, other witnesses on behalf of the defense? Yes, you may. Okay, ladies and gentlemen of the jury, that concludes the court proceedings for today. I have some witnesses coming in, but they're scheduled for a different day. Some of them are experts, so they have scheduling issues. So we are going to recess for today. We have some matters that we need to address in the morning that we can't address tonight because there's some other issues that we have to address. So we're going to have you come in at 9 o'clock tomorrow instead of at 8:30, and we're going to be here at 8:30 starting with those other issues. So you are going to be in recess for today until 9 o'clock tomorrow. During this recess, you must continue to abide by your rules governing your service as a juror. Do not discuss this case among yourselves or with anyone else, or allow anyone to discuss it in your presence. Do not speak to the lawyers, parties, or the witnesses about anything. You must avoid reading newspaper headlines and or articles relating to this trial or its participants. Avoid seeing or hearing television, radio, or internet comments about this trial. Do not conduct any research yourself. Okay, we'll see you back here at 9 a.m. tomorrow morning. Okay, thank you.
All rise.
Okay, please be seated. I have a copy of Ms. Kirshner's previous testimony. I guess they just did the whole thing because it was easier for them to do that. So I'll give a copy of the DVD to both the state and a copy to the defense, so you can review that with regard to the issue that we're going to address at 8:30 in the morning. I want to address the Brett Cook issue. with regard to the prior inconsistent statement of Ms. Kirschner. We want to do that at 8:30. Now, I heard that there may be some objections to the Palm Bay police officers. Can we do those tonight? Can we do those at this time?
Yes.
Okay, then, Mr. Brown, if you'd like to go forward on that.
If I can provide to the court, and I assume that Mr. Lanning is the supplemental witness list, March 24th, listing Officer Laronta and Officer Reed.
Yeah.
If I can provide that to the court, and attached to it is the narrative by Officer Laronta, which is fairly short, right? Kind of give the court an idea of what.
Okay?
Judge, our position.
That narrative goes into the third page.
Yes. Judge, our position on this is
And which police officer is that? Is that both?
Yeah, Officer Reardon was the supervisor.
Officer,
Reardon was the supervisor with Officer Laronka.
and it's Veronka?
I think that's,
Woronka, W-O-R-O-N-K-A.
Okay?
Judge, and obviously, the court's had a chance to review it, so they're going into an incident that occurred on April 16th, 2012, with Mr. Dieguez and what he did and possible drug use that he did on that day. Our position is it's not relevant. Prior acts and prior drug use of a witness come into play for two circumstances. One, at the time of the observation of what they're testifying to, and drug use at the time they're testifying, as far as their ability to recall. The defenses went into both of those with him, and that's been covered. It is improper to go into drug use for other time periods, as if it's a prior bad act, to try to attack the person's credibility, and that's all this is. And as far as any attempted suicide or anything like that, again, that's prior bad act. It's certainly not relevant. It's nothing but character assassination. So our position is it's not relevant, and it should not come in, but it's simply not admissible.
Okay, Mr. Lanning.
Judge. Dieguez testified
It's April 16th of 2012. He was given a statement to the Palm Bay detectives. He also testified that the reason he couldn't recall the details of the interview was that he had been stabbed and was in the hospital under sedation. I mean, he had the gall to come into court and commit perjury. And this is not, yeah, it's a fact that he was using drugs that night. And another thing that goes towards that is he was on probation at the time. And his probation orders say, you shall not use illegal substances. He was injecting cocaine that night. Of course it's relevant.
Okay, let me just get the time straight. What was the date that he gave the interview with the...
April 16th, 2012.
And that was the date that he was admitted for
Palm Bay
an
Hospital.
alleged overdose due to cocaine use.
Yes, ma'am.
Okay, go ahead.
So it's relevant towards impeaching his testimony in court. I didn't know he was going to pop out with Well, the reason I didn't remember was that day I've been stabbed and robbed. So it impeaches that. It goes toward his possible violation of his probation. And another reason to lie. And it goes toward, under 9608, it goes toward subsection 1, 2, 4, and 5.
Okay, how would his violation of probation be relevant in these proceedings? Other than bad character evidence?
He's got motivation to lie, to curry favor with the state, curry favor with law enforcement officers, not go to jail, not go to prison.
And you want to get this in as a prior inconsistent statement?
Prior inconsistent statement, and as well as evidence that tends to show a defect of capacity, ability, opportunity in the witness to observe, remember, or recount the matters about which the witness testified, proof by other witnesses that material facts are not as testified to by the witness. Inconsistent statement.
Okay, anything further by the state?
Judge, the relevance is what he heard on March 6, 2012. That's what this testimony is to. That's the relevance. That's the time frame you look at as to drug use. We're talking here over a month later. It's not relevant to what he heard or observed at the time he heard or observed it, which is the March 6th incident. Or you can have relevance of drug use comes in if it's affecting their ability to testify in court. So you get two time frames to look at. This is over a month later. The date of his police interview that's not relevant because that's just simply the day he's talking to the police. That's not the day he observed or heard what it is he testified to seeing or observing, in this case, the hearing. It's what he heard on March 6th. What he did April 16th has no relevance. Certainly the fact that someone's on probation, that fact alone comes in, not potential action you went out to do, like in the probation argument, not potential acts that you may have been out there violating probation. There's no active violation of probation at the time. That's just a red herring to try to get in any prior bad act of any witness, state witness who happens to be serving probation. By that relevance, every time they speed, everything they do that might violate probation would suddenly become relevant over the entire 2-year time frame. And my position is I don't believe there's any case law that supports that.
Okay, what about, I'm not concerned about the violation of probation, but what about credibility what about going towards his credibility? That
he used drugs on...
No, that he testified that he was there in the hospital because he was stabbed and robbed, and that may not be and the defense's argument is that's not the true reason why he was in the hospital. Now, I don't know if that's truthful or not truthful. I'm just saying that that's their argument.
Judge, first, our argument would be it's extrinsic evidence. It's not collateral, therefore, on the collateral, it has to be, it's a collateral matter, extrinsic evidence, not a use. So, at a certain point, you don't get a chance to bring in extrinsic evidence of every statement. It has to be material. The reason why he's in the hospital isn't material, because that was simply coming up as to whether or not he remembered his statement with the police. And his position was, I don't even remember talking to him. And he said, it's because I was in the hospital. Now, he doesn't remember that conversation. Maybe he's wrong what he did for it. And this occurred at 6:48 in the morning. They certainly haven't established that when he was in the hospital, when the police talked to them, it's because of something that occurred at 648. For all we know at this point, there may have been a stabbing later, and he got stabbed later in the day. So
My concern is that I don't recall the defense asking Mr. Dieguez, isn't it true that the real reason why you were in the hospital was because you were ODing on cocaine?
The fact is, we didn't know. It was actually something he pops out with that was non-responsive to the question. After the court broke that day, I said, myself, there's no way that's true. And I asked our investigator to see if they could find out why he was at the hospital. And they called, and he's Form 52. He went directly from there to Circles of Care, according to the officer report. He was taken to the hospital because of a suicide attempt.
Yeah, but are you trying to get in his statement that he was injecting cocaine and trying to commit suicide, or are you trying to get in that the reason he was in the hospital is for a cocaine overdose?
Well, it's both.
Well, because one's a prior inconsistent statement, and then the other one is, one would be an act, a fact, or an alleged fact.
Right.
Because so there's two different criterias to get those in.
Right. He didn't say anything to the officer about having been stabbed or robbed. Okay? That's prior inconsistent because of the material omission. And that he wasn't there. Also wanted that he told him he had been injecting cocaine and it was a suicide attempt. He slashed his wrist. He told him he didn't want to wake up. He's tired of life because he's in a lot of pain and wants to die. He's not at the hospital because he got stabbed and robbed. He committed perjury in court. In a capital murder.
Okay, that goes to credibility, and I didn't hear anybody ask him, isn't it true you were in the hospital because of an overdose for cocaine?
Because we didn't know until that day, or it wasn't until asking investigators, find out. Because I know he's lying, but he comes up out of the blue with this, he's in the hospital because, in court. That's the first time, and it wasn't even responsive.
He gave a proffer, and he told that during the proffer as well.
Well, it was the same day.
You're saying that because apparently that statement was out there. Where did you get that statement? I assume, did you just look at that statement that day, or did you have that statement in discovery?
Are you talking about the police interview?
Yes. No, the police.
The police interview we've had in discovery, they didn't address during the police interview why he's at the hospital.
But the statement that I just read that Mr. Brown provided to me, when did you get that information?
The day after his testimony.
Okay. What about the defense's response to its extrinsic evidence, and therefore not relevant?
It's not extrinsic. It shows a defect of capacity. The witness to observe, remember, recount matters about which the witness testified. It was his explanation as to why he couldn't remember certain matters during his interview. So it's not extrinsic. It's simple.
Well, I think you may be able to you can't get it as his statement unless you question him about it first. So you would have to call him to the stand and ask him the exact statement. You could get in about that he was really in the hospital for an alleged overdose of cocaine. That you may be able to get in. I don't know if your investigators could be able to get it in, but you may be able to get that in. Because that goes to his credibility and his ability to testify truthfully.
Well, Officer Lagarda to testify as to that.
But he can't say what he said unless you give him an opportunity to be, because it's hearsay and it won't come in unless there's a prior inconsistent statement.
We need to get Mr. Dieguez up here prior to the officer.
Well, that may be what you need to do. I can't say that. But that may be what needs to be done. But at this time, I'm going to sustain the objection as to the statement. And I'm going to overrule the objection as to the reason why he was in the hospital. Is there any questions or concerns? Does anyone want any clarification with regard to my rule? I don't want your officer to come in here and say that he had been shooting up cocaine all the night before trying to commit suicide. Your officer could say that if he had direct involvement and he is the appropriate person, could say he was in the hospital because of an alleged overdose of cocaine.
The officer could say,
If he has that information, is he the one that, did he transport him to did he take him to the hospital? Did he?
he got that information from Mr. Dieguez, filled out, or she got that information from Mr. Dieguez, filled out a Form 52.
Okay, she Form 52'd him?
Yes.
Well, then she could say that based on what he told me, I Form 52'd him.
And that he did not, and that he did
Yeah,
not.
but she can't say what it is. She can't say what it is.
And that he did not, when she could say that he attempted overdose, attempted suicide.
It's not the attempted suicide. It's not the attempted suicide that attacks his credibility. It's the use of cocaine.
Right, that he used cocaine so that she Form 52, which is Baker Act.
You would say it was an alleged overdose of cocaine.
Right, and that he did not, there was no indication that he had been stabbed or robbed.
She can say she doesn't know he's been robbed, but she could say she saw no stab wounds on him.
She can what?
She can visually say I saw no stab wounds on him.
Okay.
She doesn't, the robbing would be, she could say she didn't take a report for stabbing or robbing. She can testify as to what she did.
All right. Okay.
He still objects because it's all based on a hearsay statement. And that would be like us calling an officer and saying, did you talk to victim Y? Yes, I did. Now telling us what victim Y did, what he did.
Well, we do that all the time. We do, that's trials. You don't say what they said, you just said what you do as a result of talking
As
to
a
them.
result of what you're told, you turn around and say, I went over and arrested person X for robbery. That is not permissible.
Well, the issue is not, the issue is credibility, that he lied. It's not that he really did, the issue is not that he tried to commit suicide by the use of injecting cocaine. That would be the truth of the matter. The issue is that he said he testified in court that he went to the hospital because he was stabbed and robbed.
A month and a half after the incident, their
It goes
question
to-
was, why do you not remember your police interview? And that was his explanation for not remembering the police interview. That's the only basis, and that was his response
They
to
can
their
attack
question.
the credit because you want them to believe the truth of what Mr. Dieguez is saying, so they can attack his credibility as that he's untruthful. So as long as we keep it to those clarifications. If they want more, they'll have to do something different. Okay, other issues. I have a couple other issues.
I have, Ms. Sullivan took out correspondence, and this is what's left.
Okay, that's one of them.
This is the new, that's Exhibit B, so if I may give this to the clerk, so
Which is the new defense exhibit B?
one without the correspondence, this is the correspondence with a B on it.
Okay, does the state want to go through that? You're good? Okay, if we could, is there going to be, what?
This takes out.
Okay,
No, it's not correspondence.
okay. She's going to mark, it's going to come in, the records without the correspondence will be number 2, and the other one, the remaining is just going to be B. It didn't come in.
And also, that takes, the packet of correspondence in it as a number sequence, so there should be an instruction to do it with it that items that were not for your consideration were removed and they should not draw any differences in the fact that there may be other sequence.
I mean, I told them I was going to remove some things, so,
That's fine. I think that's
okay. I don't think they'll have that expectation with all due respect. Okay, psychotropic medications. Mr. Moore, I assume you haven't had a chance to follow up on that. Okay, if you could follow up on that before tomorrow, so we can address that at 8:32. Okay, anything else we need to address before we recess?
No, Your Honor.
Okay, court will be in recess until, for us, till 8:30. The jury will be back at 9. Okay, thank you.